Let me, on behalf of the 10 Senates of the Federal Republic of Nigeria, welcome strangers into the hallowed chambers of the Senate of the Federal Republic of Nigeria, in this case led by the acting Chief Justice of Nigeria, Justice Kudirat Motomori, Olatokunbo Kekerekun, CFR. Unfortunately, my Lord, in the Senate, we don't clap. We would have clapped for you. So I want to also welcome your brother justices of the Supreme Court of Nigeria, the president of the Court of Appeal of Nigeria, and other justices, and also welcome the heads of various courts, the Federal High Court, the heads of the High Court of the FCT, and of course the Secretary of the NJC, and the Secretary of the Federal High Court Judicial Service. I have seen the ones I can recognize from here, but this is the top echelon of the Nigerian judiciary. Upon your shoulders rests justice for us and also for the common man. I must say that when it comes to issue of justice, it concerns all and sundry. And so this screening and confirmation is of immense interest to all Nigerians. I'm taking this liberty of the distribution of the CVs to do this brief introduction or brief comments. Otherwise, there would have been no time, would have gone straight into business. But I want my colleagues to peruse through the CVs as they are being distributed now. So the press to shift a little to enable us capture from the special advisor to Mr. President on Senate matters, Senator Lado, all the way down. In no particular order, I believe I know a lot of the justices of the Supreme Court who are here to honor the Senate and also honor the incoming Chief Justice of Nigeria, who is currently in acting capacity. So I welcome all of you. I wish you good health and God's protection. Yes, Leader of the Senate.
I would like to read the provision. Thank you. Section 231, sub 1, says the appointment of a person to the office of Chief Justice of Nigeria shall be made by the President on the recommendation of the National Judicial Council, subject to confirmation of such appointment by the Senate. Mr. President, it's important that we say for the record that the judiciary is one arm of government that has continued to be consistent in ensuring that they follow their rules and that in ensuring that the most senior justice of the Court of Appeal is nominated, of the Supreme Court is nominated as the incoming Chief Justice of Nigeria. And Mr. President, this cannot be lost on us, and it should not be lost on Nigerians, because it's important that we follow our own rules. I want to also commend Mr. President for ensuring that nothing took this administration out of this consistency. And having said that, Mr. President, sitting as chair, distinguished colleagues, what is left for me, this being the committee of the whole, is just to most respectfully at this point present, standing before this Senate and in this hallowed chamber, the acting Chief Justice of Nigeria, who, if and when confirmed by this president, would be the next, confirmed by this Senate, would be the next substantive Chief Justice of Nigeria. And she had earlier been introduced. She doesn't need any elaborate introduction. It's known to all and sundry. And you have also rightly welcomed her and members of her entourage into the Senate. But Mr. President, may you and our distinguished colleagues kindly please take legislative notice of the fact that the acting CJN is here standing before us and is ready for the confirmation hearing of this Senator. Thank you, Mr. President.
The Deputy Senate President, the principal officers of the Senate, distinguished senators, my family members who are here, my husband, Mr. Akpabio, and my brother, Honorable H.A.B. Fasano, my colleagues of the Supreme Court, Honorable Justices of the Supreme Court, the President of the Court of Appeal, President of the National Industrial Court, the Chief Judge of the High Court of the Federal Capital Territory, the President of the Sharia Court of Appeal, the President of Abuja FCT, distinguished ladies and gentlemen. My name is Kudirat Mutomori Olatokunbo Kekeriekun. I was born on the 7th of May, 1958 in London, UK, to the family of Alhaji Senator H.A.B. Fasenro of Erelu Square, Isaleko, Lagos, and Mrs. Winifred Laiwola Ogundimu, née Savage of Ologbo area, Lagos, both of Lagos Central Senatorial District. I'm happy to say that my father was once in this hallowed chamber Ikoyi and Corona School Ikoyi, from where I moved to Queen's College Yaba for my secondary education. I obtained my ordinary level school certificate in 1974 and my higher school certificate in 1976. Of Lagos in 1977, and I graduated in 1980. Thereafter, I proceeded to the Nigerian Law School, and I was called to the Nigerian Bar on the 10th of July, 1981. After my call, I proceeded for the one-year compulsory national youth service. I served in the old Bendel State, now Edo State, and I served as a state counsel in the Ministry of Justice Legal Drafting Department. After my youth service, I proceeded to the London School of Economics and Political Science, where I obtained a master's degree in law. Thereafter, I obtained the master's degree in 1983. And from that time, I was in private legal practice until 1989, when I joined the lower bench as a magistrate grade 2. I rose to the position of Chief Magistrate grade 2, and from there was appointed a judge of the High Court of Lagos State on the 19th of July, 1996. Shortly after my appointment as a High Court judge, firearms tribunals. I chaired that tribunal from 1996 until 1999, when those tribunals were abolished. At the same time, I was also carrying out my regular duties as a judge of the High Court. I had several ad hoc assignments during that time. Two of them that are quite worthy of mention is I was a member of the committee that drafted the Lagos State High Court Civil Procedure Rules in 2004. Those rules brought in a lot of reform in civil procedure. They introduced new concepts such as front-loading, where you file all the documents you intend to rely on along with your originating process, as long as witness statements on oath, so that it will cut down the time spent on trial by starting immediately with cross-examination. We also introduced compulsory reference to ADR, and those rules became the model for all the states of the Federation. Another innovation while I was in the High Court was I was a member of the steering committee of the Lagos State Multi-Door Courthouse. That is the first court-connected ADR center in Africa. That model has also been adopted across the Federation to reduce dockets and speed trials. From the High Court, I was elevated to the Court of Appeal in September 2004. While at the Court of Appeal, I served in various divisions. I served in Kaduna, Port Harcourt, Ibadan, Makurdi, and Akure divisions. I was the first presiding justice in the Makurdi division of the Court of Appeal. I set up that division of the Court of Appeal. I also served on the Information Technology Committee of the Court of Appeal. By the grace of God, on the 8th of July 2013, I was appointed a justice of the Supreme Court of Nigeria. I was the 5th female to be appointed to such a position. In the course of my career as a judicial officer, I have always strived to maintain my integrity, to uphold the rule of law, to ensure that I do justice in all the matters that come before me. Some of these positions that I have mentioned, I believe, have also shown my leadership qualities. Presently, I am the chairman now of the National Judicial Council, but I had served as the vice chairman of the National Judicial Council and also the chairman of the interview committee. I'm also on the board of governors of the National Judicial Institute and chairman of the education committee. I also serve on the Legal Practitioners Privileges Committee. I'm also a member of a subcommittee of the Body of Benchers that looked into conflicting judgments, the challenge of conflicting judgments. I have also received many awards for my work, my dedication. I've been honored 3 times by the Lagos State Judiciary. I've been honored by the Women Lawyers Forum and so many others. By the grace of God, I was conferred with the national honor of Commander of the Order of the Federal Republic in October 2022. I am a life bencher. I'm a fellow of the National Judicial Institute, a fellow of the Nigerian Institute of Advanced Legal Studies, and also a fellow of the Dispute Resolution Institute, International Dispute Resolution. These are my credentials, and I stand before you today with a pledge to do my best to uphold the integrity of the judiciary, to uphold the rule of law, to ensure that we defend the Constitution, and to work for the service and interest of all Nigerians. Thank you very much. Thank you, Mr. President.
Colleagues, you have heard from the Acting Chief Justice of Nigeria, who is here before you, and I just want to employ her to take her seat while she's jotting down the questions. So you may decide to take 2 questions at a time, or 3 questions, but you will sit down and jot down the questions. We don't want you to stand throughout.
Thank you. Thank you, Your Excellency.
Well, you are here for screening. And I think the best aspect of determining the suitability of every nominee by these chambers, number one is the practical performance of such a nominee. For you, we've known you over the years. We've known your exploits in the judiciary of this nation. Been following you. You are known to us. And you've done very, very well. And you are still doing very well. That said, the CV you brought here is loaded with your excellent performance, exploits in the judiciary. That's not in doubt. Well loaded. It shows you have a wonderful pedigree in line with your practical performance. This we all know. So to me, you are highly suitable for this position. This is my personal opinion, and I'm sure most of my colleagues here share the same opinion with me. That said, I will want to ask you a question, because I want you to bring your sound pedigree to bear in your office when confirmed as the substantive Chief Justice of Nigeria. We know that having, integrity in our judiciary is something that is important, sine qua non for the sustenance of our democracy. Now, what will you do when confirmed as the substantive Chief Justice of Nigeria to ensure that you uphold, or we all uphold, or you uphold the integrity of our judiciary?
There is a school of thought to the effect that there is need to create a constitutional court that will be vested with the jurisdiction to determine election-related matters. So I want your opinion on this. Well, where do you stand? Where do you stand as a renowned jurist that has attained your present position? Where do you stand on these issues that are raised?
The Deputy Senate President, Senator Barrow, you asked about how the integrity of the judiciary will be sustained under my leadership. I think the first thing in giving my CV, I said one of the things that I'm known for is integrity. I'm also known for being strict on discipline. And therefore, in order to ensure that the integrity of the judiciary is maintained, I will ensure that the code of conduct is fully complied with. I will ensure that there is zero tolerance for corruption. We have a committee of the NJC that deals with performance evaluation. And what that does is they assess judgments delivered, they assess how judges are performing their functions, and they have regular conferences. And what I know is that we are even making moves now to tighten that performance evaluation process so that we can, when they submit returns, when judges submit returns, for instance, it's not about quality, but quantity. It's also about how they carry out their responsibilities. Are they punctual? Are they upright? And things like that. Now, in the NJC also, we are going to ensure that petitions are dealt with speedily. This is another way to let the public know that the integrity of the judiciary will be upheld in all circumstances. Another area for upholding the integrity of the judiciary is that there is a need also to insulate the judiciary from external influence. We are very grateful to His Excellency, the President and Commander-in-Chief of the Armed Forces, President Ahmed Bola Tinubu, and the National Assembly for passing the bill that increased salaries of judicial officers. We are very grateful. But there is still a way to go. Because when we are talking about the integrity of the judiciary, it involves not only the take-home pay, it also involves infrastructure that we are working with. What is available? Is it conducive? These are all things that have an effect on how the judiciary performs and what. So in that regard, I will be pushing for still more better welfare for judicial officers so that they too can perform at their optimum best. Thank you. The Chief Whip, Senator Tahir Mongono, representing Borno North. Distinguished Senator, you have asked about the judiciary, the independence of the judiciary, and I know that there are a lot of complaints at the moment about the process of appointment of judicial officers. This is an area that I'm also going to take very, very seriously. The NJC also has a committee working on this to ensure that we make the screening process rigorous, transparent, and something that the citizenry will be satisfied with when judges are appointed. So I'm going to make sure that this is done, and with dispatch. We are looking at other jurisdictions to see how they carry out this process and how we can improve our own process in that regard. I know that once the citizens are comfortable with the manner in which judicial officers are appointed, it makes them have more confidence in the entire system. I will also be encouraging or supporting improvement in our laws. So again, when it comes to the independence of the judiciary, all hands have to be on deck. And I look forward to working with not only the National Assembly, but also the executive to ensure that we have laws in place that enhance our independence. Stagnation of cases in the Supreme Court, whether the number of cases that go to the Supreme Court should be restricted. I am very firmly of the view that there needs to be a limit to the cases that get to the Supreme Court. One of the reasons for this is that the Supreme Court is a policy court. It's supposed to determine matters that have public policy significance, matters relating to the interpretation of the Constitution, or matters where very rare legal issues have come up which require a pronouncement from the Supreme Court. As you know, the constitutional provision gives us 90 days to deliver judgment from the date of final address. Those 90 days are spent dealing with matters of national significance as well as matters that have no significance on the national stage. I am of the view that many matters should terminate at the Court of Appeal, especially interlocutory appeals. There's also a situation where pre-election matters come all the way to the Supreme Court, whereas in national and state assembly elections, the substantive elections terminate at the Court of Appeal. I think all pre-election matters should terminate at the Court of Appeal. So many matters need to terminate at the Court of Appeal so that the Supreme Court can really live up to its designation as a policy court. Thank you very much. I don't believe enlarging the number of justices is the solution because the cases are so many. The backlog is tremendous. So even if you increase the number of justices, I believe that sometimes it gives the impression that, oh, there are more justices, so we can even file more appeals. It's more about the jurisdiction of the court, which I think should be limited. Thank you. I think His Excellency, the President of the Senate, has responded to the issue regarding elections. All I would say is that we need to strengthen our institutions, strengthen our attitude to elections so that people have confidence in the system and will not be encouraged to go to court all the time. The chairman of the Senate Committee on the Judiciary, Human Rights and Legal Matters, you have raised the question about conflicting judgments, and we know that this is a very serious concern. Now we have what is known as the doctrine of stare decisis, where a lower court is expected to follow the decisions of a higher court. Where it is shown that a judicial officer deliberately fails to follow that doctrine, there will be strict consequences. Also, it is necessary because there are so many complaints about conflicting judgments that where these conflicting judgments occur, there will be a need to have committees that will look into them and see how the court can take a position. The proper procedure will take place. The court cannot sit on appeal over its own decisions, but where these matters arise, the court's attention will be brought to them and they will be dealt with speedily. In the Supreme Court, for instance, where the court's attention is drawn to any of such matters, those matters will be fixed expeditiously so that those issues can be resolved. We know that it is a serious problem. It is also an act of misconduct if a judicial officer fails to follow laid down precedent. So this is something that is going to be tackled seriously. And yes, so in terms of the code of conduct, we will be dealing very decisively with matters where we find that this is happening. I also want to say that there are responsibilities for both the bar and the bench. So in this kind of situation, you also have legal practitioners who are aware of the existing precedent and they come and mislead the court. So as the head of the judiciary, I shall ensure that both the bar and the bench are up and doing in this regard, so that the legal practitioners disciplinary committee can also deal with those legal practitioners who are found to have deliberately misled the court. Another reason why you have some of these conflicting decisions is from what I would call forum shopping. So this is another area that will be tackled very seriously and very decisively. Thank you very much.
Mr. President, my question to the CJM. When you talk about autonomy, when you talk about independence, you are also talking about autonomy. I happen to chair the committee that on the side of governors that was fighting for the issue of autonomy and independence for the judiciary. We took the steps and we got up to Supreme Court on one aspect. My concern was that aspect that was rejected by the Supreme Court, and that has to do with the capital component. In other words, we are saying that they should, when you are taking charge of autonomy, you want to be autonomous, you must also be autonomous in all aspects, including capital projects. But surprisingly, we took the matter up to Supreme Court, and the Supreme Court rejected it, rejected autonomy. I say this because when we are talking about my interpretation, not as a lawyer, as a politician, is that when you are talking of autonomy, independence, you must carry everything. It must all be inclusive and also bear the consequences. And so I'm asking my Lord, do you still stand by that, or there is need for reconsideration?
Excellency.
June 2024, the Nigerian Labour Congress and Trade Union Congress, along with their affiliates, embarked on an indefinite strike to demand for increase in the minimum wage of workers as a direct response to cushion the effect of fuel subsidy removal, amongst other economic measures adopted by the current administration. Aware also that the federal government, being mindful of the harsh economic realities and the need to ensure smooth economic transition to alleviate the burdens on citizens, put some measures in place, which include, but not limited, to the wage award of 35,000 naira per month across the board, financial assistance through direct transfers, public transport regulation mechanism, and so on. Senate recalls that the federal government on the 2nd April 2024 set up a 37-man tripartite committee with its membership drawn from the federal, state governments, organized labor, and the private sector. The terms of reference of the committee, among other things, is to recommend a new national minimum wage for the country. Also recall that the wage award, which was introduced by the federal government in September 2023, was expected to last for a period of 6 months, within which all the negotiations and deliberations on the new minimum wage must have been concluded. However, the assignment is still going on due largely to due to conditions on the part of the organized labor and the federal government to reach an agreement and have a common ground on the matter. In spite of this development, the federal government, not being oblivious of the hardships of Nigerians are passing through, extended indefinitely the payment of the wage award pending the final determination of the national minimum wage, as discussions are further negotiations are still on. Senate notes that in spite of the efforts demonstrated by the federal government, the organized labor embarked on another indefinite strike, which has shut down all socio-economic activities in the country, particularly in the areas of health, national grid, the ongoing WAEC examination, and air travels, amongst others. This, without doubt, has dire and dilapidating effects on our well-being and economies and the country's economy. Senate also notes that globally, there is dwindling economic downturn, and Nigeria is not an exception. As such, all hands must be on deck to ensure that collectively we can overcome these challenges we are confronted with as a nation. Senate further notes that consequent upon the meeting held between organized labor and the federal government on Monday, 3rd June 2024, and the resolution reached therein, it is imperative that the organized labor suspends the ongoing indefinite strike to pave way for further negotiations, which are already yielding positive results. Accordingly, Senate resolves to urge the Nigerian Labour Congress and the Trade Union Congress and all other affiliates to, as a matter of urgency and patriotism, call off the indefinite strike action embarked upon by them and return to negotiation table, which is still ongoing. 2, Senate urged the federal government to put measures and modalities in place with a view to nipping in the bud the ugly situation and finally lay to rest the controversy surrounding the national minimum wage matter, as Nigeria cannot afford the huge economic losses occasioned by the industrial action, which has so far-reaching effect on the economy. And Senate urged both parties to adopt diplomacy and devise a means of arriving at a comprehensive policy that would be beneficial to both the private and public sectors in a way that will not drive the economy to an unprecedented downturn that would lead to a mass laying off of workers in the private sector and leading to retention by government workers. This is my motion for debate. Thank you for the opportunity.
Yes, distinguished Deputy Senate President.
In the justice delivery sector, like the police, the security agencies, correctional centers, and so on. Because it is not just the job of the judges. All the stakeholders need to be involved and need to be on the same page in terms of wanting matters to be concluded speedily. I believe that the position we are in now, where there are so many negative comments about the judiciary, that this is a time that all hands should be on deck to ensure that we actually serve the people freely, fairly, transparently, and effectively. Distinguished Senator Mustafa, Kwara Central, access to justice. How will I enhance access to justice? Again, apart from adopting proactive rules of court, the digitization of the judiciary should also help, because we will also have websites that would have necessary information about what the court is doing, and also judgments to be published as soon as they are delivered. This is something that I will work towards, so that the public, when we are fully digitized, can go on their computers and find out any information about any of our courts in the shortest possible time. We also look at other impediments to access to justice, moving justice closer to the people, being more open, and also to liberalize our processes so that more people can access the courts. Another point I would make is that in addition to matters going before the courts, I will also promote ADR, that is Alternative Dispute Resolution, because this is a way in which we can decongest our courts and everybody can leave the determination of their matter feeling confident. What we always say is that with courts, if you have matters in court, there's always a victor and a vanquished. Whereas when you refer matters to ADR, all the parties can live satisfied. It's also necessary to make our processes more transparent. I think that is covered by the digitization that I'm talking about. This is also capital intensive, so we will also be looking for the necessary support from the relevant institutions. Distinguished Senator Lalong, on independence of the judiciary, autonomy, and the capital component. Now, in that respect, the Supreme Court has spoken. I represent the Supreme Court. I cannot say the Supreme Court has spoken wrongly. However, if there is any situation that arises where the court's attention could be brought to, whatever it is that, you may want to have another look at, the court cannot review its judgment once delivered. So it's a matter of, if other matters come up, perhaps the court's attention could be drawn to this issue again. Another way of looking at it is that the court interpreted the Constitution as it understood it to be. As the legislature, it is up to your distinguished selves to also have another look at the law and see if there's a way to bring it in line with that decision. Distinguished Senator Musa, on whether there should be a constitutional court for election matters, terrorism, and so on. What I believe is that what is more important is looking at our systems, our processes, as I've said, because no matter how many courts we have, at one point or the other, they'll become congested, and we get back to the same problem. So it's more about looking at our systems to make them more efficient, more effective. Distinguished Senator Olamilekon, appointment of judicial officers. You mentioned interference with the appointment of judicial officers. As I've stated earlier, we will ensure that this process is more rigorous, more transparent, and more acceptable to the people. Distinguished Senator Ailero, on the negative perception of the judiciary, awaiting trial inmates and so on. In fact, we just had this week a conference, a roundtable with heads of courts, and this is one of the matters that came up. And we are exploring ways to ensure that prison decongestion is carried out frequently, so that those who need not be in our correctional centers can be released as quickly as possible. And then I've also suggested that if we have more of virtual hearing, trials would not take as long, because in criminal matters, the delay is usually the inability to produce witnesses or to produce the inmates from the correctional centers. If we have more virtual hearing, I believe this matter will be resolved. And then distinguished Senator Kaka, on interim injunction and ex parte orders. The Code of Conduct for Judicial Officers specifically speaks to interim ex parte orders, the power to grant ex parte orders, and that it must not be abused. We continue to press on all our judicial officers that in most cases, there is time to put the other side on notice. And where this power to issue ex parte orders is abused, those found responsible will be dealt with decisively. Yes, there are situations where ex parte orders are necessary, but in many cases, it may not be so. And where we are made to see that these orders have been granted indiscriminately, those involved will be dealt with decisively. The same thing with interim injunctions. Essentially, it is about judges not abusing the power that they have. And all this will be made very clear to them, and we will tighten our disciplinary procedures in this regard. Thank you very much.
I recall seeing you in the confirmation of Justice Mohammed Tanko and Justice Ariola. You accompanied both of them. And one of the highlights of those two sessions was the issue that was raised by Senator Kwaka SAN on the issue of the ex parte order and the assurances we had then received by their lordship doing something about it. These ex parte orders, my lord, has become a tsunami in Nigeria. And therefore, some of us begin to wonder, how easy are these orders assessed? I can tell you straight that 6 years ago, your lordship, I had the opportunity of visiting a political friend in his office, and he opened his box and brought 5 expatriate orders in advance. Expatriate orders in advance, and from a competent court of jurisdiction in this country. And it makes me wonder how that is possible. And you could see within the last, by the time I met him, he was using these expatriate orders. All they were doing was to fill in the gap, fill in the dates. And he has assessed these expatriate orders in anticipation of possible problems by political opponents. And believe you me, my lordship, those orders succeeded at the end of the day. Now, the question that I would like to ask you, is the hand of the judiciary tight in the possibility of not meting out sanction? Or do you need an intervention of legislation in making sure that such irresponsibility is actually made by a law of the National Assembly, making sure that it's criminalized? What's your opinion about it? I know, as a fact, you made mention of the necessity of this expatriate order, but you can see clearly it doesn't work in this country. People have these orders left, right, and center. People are trying to block road of justice at every given time. And I want, during your tenure, so that by the time the next justice is coming before the Senate, this question may not arise. But these 2 justices, they assured us something will be done, and actually nothing serious is being done about this matter. Please, I want you to comment. Thank you.
To allow debate on the matter forthwith. The motion is on the urgent need to review the security approach in addressing banditry attacks in the Northwest. That's Katsina State, Sokoto State, Zamfara, Kaduna, Kebbi, Jigawa, and Kano, sir. Well, the Senate notes that Katsina, Zamfara, Sokoto, Kebbi, Kaduna, Kano, and Jigawa states have been plagued by escalating banditry attacks.
Distinguished colleagues, Senator Zagbodara, you are seeking the permission of the Senate to proceed, right?
for the Supreme Court to unilaterally make such an order, because everything we do has to be based on the jurisdiction that is conferred on the court. Distinguished Senator Abdul Ningi from Bauchi Central, you asked for assurances with regard to ex parte orders and an issue of ex parte orders prepared in advance, whether the hands of the judiciary is tied, and whether there should be legislation against the grant of ex parte orders. Now, the situation with ex parte orders, where it is, you see, in order to have the judiciary that we desire, we also need to be able to follow through on certain issues. If there's a situation where a judge is found to have ex parte orders prepared in advance, such a judge should be reported to the NJC and necessary action will be taken. It is not fair, even on the judiciary, when these allegations are made and nothing is done to substantiate them or to follow up on them. And we know that even when petitions are filed before the NJC, in some instances, you find that the petitioner comes back and withdraws the petition. So it is important for the NJC to be able to exercise its own powers, that these sort of matters are brought to its attention. And then the grant of ex parte order is discretionary, but there are guidelines. So where a judge is found to have ignored those guidelines, to have acted without due regard to proper process, or even the facts of the matter, then the necessary action will be taken once it is brought to the attention of the National Judicial Council. As I've mentioned, the code of conduct will be strictly enforced, and judges are admonished not to grant ex parte orders indiscriminately. So it's an act of misconduct. But at the same time, it would not be proper, in my humble opinion, to enact a law that does away entirely with ex parte orders, because they are necessary in certain circumstances. Distinguished Senator Ofowe from Bayelsa Central. Pardon? Hombowe, I beg your pardon. I want to believe that his question was rhetorical, and I have, I think, the permission of His Excellency to pass it over about whether who are those corrupt people. Then, Your Excellency, your question: should judicial officers allow social media to influence their decisions? Certainly not. We have taken an oath of office to carry out our responsibilities without fear of favor, affection, or ill will. So whatever is in social media definitely should not affect the way we make our decisions. However, it is true that there is a lot that goes on social media and other fora. And this is one of the aspects that contributes to the negative perception of the judiciary, because you have narratives out there that have no correlation to the facts that are before a particular court. And again, whether they are senior members of the bar or other members of the bar, there are procedures. A senior member of the bar who has earned the rank of silk, it's a privilege. It's not a right. And that privilege could be withdrawn if it is abused. So in any of these situations, the courts too will use their own powers. We do have powers where a matter is sub judice and somebody goes out in public on the television station, media, social media, to comment on those cases, because it does have a negative effect on the administration of justice, on how we handle our cases. Because when you then give a judgment, the way it is assessed is based on what has been in social media. But notwithstanding that, I would say that judges know the oath they have taken and will abide by that oath and not be influenced by social media. Thank you.
My Lord, you were very political in the last.
So you bring it up on another day. We've already taken one. If you read very well, 4151, taken one, 4151, taken one. If you read very well, if you read very well, 4151, very well, 4151, taken one, 4151, very well, one. If you read very well, 41, read very well, 4151, take well, 4151, taken one. If you want to do very well, one. If you read very well, 41, very well, 4152, very well, 4152, taking one, 4152, very well, one. If you read very well, 40 read very well, 4152, take well, 4152, taking one. If you want to do very well, one. If you read very well, 41 very well, 4152, taking 4152, taking one. If you read very well, if you read very well, 4152, very well, 4152, take well, 4152, taking one. If you want to do very well, one. If you read very well, 41 very well, 4152, taking 4152, taking one. If you want to do very well, if you read very well, 4152, very well, 4152, take well, 4152, taking one. If you want to do very well, one. If you read very well, 41 very well, 4152, taking 4152, taking one. If you want to do very well, if you read very well, 4152, very well, 4152, taking one, 4152, taking one. If you read very well, if you read very well, 4152, very well, 4152, taking one, 4152, very well, one. If you read very well, 41 read very well, 4152, take well, 4152, taking one. If you want to do very well, one. If you read very well, 41 very well, 4152, taking 4152, taking one. If you read very well, if you read very well, 4152, very well, 4152, taking one, 4152, taking one. If you read very well, 40 read very well, 4152, very well, 4152, taking one, 4152, very well, one. If you read very well, 41 read very well, 4152, take well, 4152, taking one. If you want to do very well, if you read very well, 4152, very well, 4152, taking 4152, taking one. If you read very well, if you read very well, 4152, very well, 4152, taking one, 4152, very well, one. If you read very well, 40 read very well, 41 very well, 4152, taking 4152, taking one. If you read very well, if you read very well, 4152, very well, 4152, taking one, 4152, taking one. If you read very well, 40 read very well, 4152, take well, 4152, taking one. If you want to do very well, one. If you read very well, 41 read very well. We do step down all other items on the other paper to enable the Senate leadership to make its own position known and contribute to the ongoing debate on the new minimum wage, which is on the front burner of Nigerian politics today, and instead retain consideration of the report on the new salaries and wages for judicial officers only. Those is be stepped down to consider only the report. Say aye. Those against say nay. The ayes have it. So the Senate leader, you may proceed. You may proceed.
Digitization of the